Welcome, everyone. We're just going to take a couple minutes to let people file in, and then we'll get started. Okay, looks like we've got a lot of people in the Zoom with us, so let's go ahead and get started. Welcome, everyone. My name is Barbie Goosens. I'm the Academic Programs and Services Manager at the University of Oregon School of Law. And it is my great pleasure to welcome you to today's Oregon Law Perspectives webinar. The Oregon Law Perspectives series brings the work of our law school's faculty to our colleagues, our students, our alumni, and the broader public. This is our fourth and final session of the Summer Oregon Law Perspectives series, and it's only fitting that we would feature the wonderful Professor Howie Arnett. This will be the fourth year that we've hosted Professor Arnett in a webinar, so in short, he is our MVP. Professor Arnett has practiced law for 40 years in Arizona and in Oregon, representing tribal governments, tribal members, and Native American organizations. His law practice in Bend has included work for tribes on treaty rights, tribal sovereignty, tribal law development, government-to-government relations, water rights, and gaming. He has a bachelor's degree from Stanford, a master's degree from the London School of Economics, and a JD from the University of Oregon School of Law. Today, Professor Arnett will provide us with a review of the Supreme Court's work in Indian law this past year. The court has been very involved in this area for the past several years, and it is wonderful for us to have the opportunity to hear an expert like Howie talk about what's happened and where he thinks things are going. As the session unfolds, if you have any questions, please submit them via the Q&A function in Zoom. Only the panelists can see the questions, and you can remain anonymous if you like. We'll try to get in as many questions as we can at the end. Finally, for those of you seeking CLE credit, you'll receive an email after the event asking for your bar number so that we can submit it to the Oregon State Bar. With that, let me turn it over to Professor Howie Arnett.
Thanks, Barbie. Good afternoon, everybody. I'm going to talk about the Supreme Court term that just ended in June involving Indian law cases. There were 3 of them, and it was a big and active term. And I'll go through those. As most of you may know, if you have any involvement with Indian law at all, you know that in many respects, the whole body of Indian law is in many respects what the Supreme Court says it is. So Supreme Court decisions are really critical in the field of Indian law. So I have lots of PowerPoints. I'm going to try to get through all of them to talk about the 3 big cases that were decided by the court this last term. So I'm going to go screen share now and pull up my PowerPoints and go to slideshow from the beginning. Here we go. There were 3 big cases, Indian law cases in the Supreme Court, and they range from just huge, the Brackeen case, to very important, the Arizona versus Navajo Nation case, to significant, but probably not earth-shaking in terms of future consequences. That's the Flambeau case involving the bankruptcy code and its application to tribes. So I'm going to go through all three of these. The Brackeen case, this was one of those cases, rare Indian cases, that actually makes national headlines outside of the sort of narrow world of Indian law and tribal law. And as many of you may know, it involves the constitutionality of the Indian Child Welfare Act, a hugely important 1978 statute. And this case was very, very closely watched, and I'll go through and explain why. In part because not only was the future of the Indian Child Welfare Act at stake, but the consequences of a loss on the two critical issues raised by the plaintiffs in this case really reach beyond Indian law. They threaten the fundamental foundation principles of Indian law in a couple of important respects. And it's not an understatement or an overstatement and hyperbole to say that the litigation posed an existential threat to Indian law, and I'll go through that. So when the decision was announced that the tribes won 7-2, that nobody I knew predicted that, there was jubilation in Indian country. It's one of those things where everybody who's in that world, and I'm certainly in that world, I've represented tribes and taught Indian law for over 40 years. So I'm pretty firmly in the tribal camp, as you'll tell when I go through the presentation today. Everybody knows where they were when they heard the word that the tribes had won this case. I was driving through Cascade Locks, Oregon at 7 a.m. in the morning, coming from Stevenson, Washington, on my way to Bend, Oregon, listening to NPR, and top of the hour at 7 o'clock, the headline was "Tribes Win Adoption Case." And 7 o'clock is 10 o'clock in Washington, D.C. That's when the opinions are reached from the Supreme Court. This was in mid-June. And I knew what that meant. And then an hour later, Nina Tiltberg got on and explained a little bit more about the case and the decision, that it was 7-2. And I thought, I got to get to my office and read this thing and see how it turned out. So we'll parse through it here in a minute. The Arizona versus Navajo Nation case is a case about two pillared Indian law, the Indian Reserve Rights Doctrine, Water Rights Doctrine, also known as the Witters Doctrine, and the Trust Responsibility Doctrine, and how they work together, or in this case, don't work well together for purposes of the Navajo Nation and its reserved water rights. They lost that case. Lac de Flambeau, as I said, is a little less earth-shaking case, although the tribe lost. On the law, it was a tough call, tough case. The circuits were split on this question of the bankruptcy code and its application to tribes, and whether Congress intended a waiver of tribal sovereign immunity in the statute. But the Supreme Court didn't have any trouble at all. 8-1, tribe loses. And it might have something to do with the facts in the case that were troubling. So we'll go through that. So Brackeen first. Before I do that, I wanted to talk about what I saw as an emerging theme coming out of this term in the Supreme Court, and also looking back at previous years, recent years in the Supreme Court. And the theme I saw is the theme of two justices, Justice Gorsuch and Justice Thomas. Justice Gorsuch, as I think everybody knows, particularly in the Indian law tribal world, is a strong advocate for tribal rights and a protector of the legal principles that form the foundation of federal Indian law. And he always writes, whether it's a concurring opinion, a majority opinion, a dissenting opinion in an Indian law case, virtually always. And when he writes long and he writes beautifully about the historical and enduring nature of these basic foundation principles of Indian law. He's sort of like he's educating the rest of the court and the public at large about Indian law. He takes that on and he does a wonderful job of that. At the other end of the spectrum is Justice Thomas. Now, Justice Gorsuch and Justice Thomas are really aligned in a lot of respects. They're contributed or assigned at sort of the conservative end of the bench in the Supreme Court, and they vote in alignment many times, but not on Indian law. And Justice Thomas, his view, and he writes frequently on Indian law cases, concurring opinions, several of them in the cases in this last term. And he keeps pointing out that Indian law foundation principles have no basis in the Constitution, in his view. And he questions the trust responsibility doctrine, many other doctrines we'll see as we go through the cases that he just questions, where did they come from? Well, what he says is they all came from the Supreme Court. The Supreme Court just made up these foundation principles. They don't have any foundation in the Constitution. And it really would be a good idea for the court to re-examine these foundation principles. Since they made them up, the court can unmake them if they want to. So he's at the other end of the solar system from an Indian law perspective in terms of the court's view, Justice Gorsuch and Justice Thomas. So let's talk about the Brackeen case first. This case was so big, it's been percolating through the lower courts, up from the Federal District Court in Fort Worth, Texas, to the Fifth Circuit, then to the Supreme Court for years, number of years it's taken to get there. And when cert was accepted and the Supreme Court had this case lined up for this last term, it was so important that we did this Indian Oregon Law Perspectives webinar last year in September on the Brackeen case, and Professor Epps, a constitutional law professor at Oregon, and I talked about what's going to happen with this case in the Supreme Court. So it was that important. A little background about the Indian Child Welfare Act. It's probably the most consequential piece of Indian legislation from Congress in the last half century. There are 574 federally recognized tribes, and virtually every one of them has some involvement in the Indian Child Welfare Act. It affects all of them. The problem the Indian Child Welfare Act is intended to address and does address is this phenomena in the 1950s, 1960s, 1970s of this alarmingly high rate of broken Indian families caused by really state court child custody proceedings, foster care and adoption proceedings, termination of parental rights involving Indian families, and the placement of these Indian children in primarily non-Indian homes, either through foster care or adoption placement, which has the effect of breaking up Indian families. And the statistics were staggering. 25 to 35% of all Indian children had been separated from their parents through these state court proceedings. 85 to 90% of these children who were placed in placement outside of their own home went to non-Indian homes, which would have the effect of severing the child's tie with their own tribal community and so on. And the states were found by Congress to have contributed to this by failing to recognize the essential nature of family relationships and tribal communities. So how does the statute work? Well, as I said, the basic aim is to keep Indian children connected to their Indian families. The key statute definition is that of an Indian child. This is what the statute applies to in a state court child custody proceeding, adoption or foster care, involuntary or voluntary proceeding, if it involves an Indian child. Indian child is defined as a child who's an enrolled member of a federally recognized tribe, one of the 574 tribes. Or it goes beyond that and also covers children who are not enrolled but could be enrolled. They're eligible for enrollment, and plus they have one biological parent who's an enrolled member. The reason for that is that for most tribes, the enrollment doesn't happen automatically upon birth of a child to tribal member parents. There's an application process, a determination if the child meets the eligibility requirements of that tribe for membership. And it takes a little while sometimes, months or even years, for a child after birth to become enrolled in the child's tribe. So the statute was intended to cover those circumstances if a state court child custody proceeding should involve a child who could be enrolled but isn't yet enrolled. So that's why the definition is a little broader. That created some issues in terms of equal protection and the scope of the statute. From the basis of perspective of the challengers, the plaintiffs. The statute itself provides procedural protections and substantive standards to raise the bar on breaking up Indian families in a state court proceeding, make it more difficult to try to preserve the family and keep the kids with their parents, and so on. And then it also provides for placement preferences, foster care, adoption placement, to try and, if there is going to be a placement of the child outside of his family home, his Indian family home, he's going to be placed, the first priority would be with his own extended family. Second priority would be families in the child's tribe. Third priority would be other Indian families in other tribes. And that actual issue, that third default placement, other Indian tribes, became an issue in this litigation in terms of an equal protection challenge, as we'll see and we talk about here a little bit. These placement preferences, all three of them, outrank non-Indian families in terms of a placement. Child's own family, other families in the child's tribe, or families in other Indian tribes. So that's how the statute works, and it's also the cause of the controversy about it. The case involved three sets of non-Indian parents. The Brackeens are one of them. There are two others. They're seeking to adopt Indian children. And then along with the the state of Texas, they sued the Secretary of Interior, Deb Haaland now, and the United States and other federal officials in federal district court in Fort Worth, Texas. The same federal district court that had earlier ruled the Affordable Care Act, Obamacare, unconstitutional. So this looked like a favorable forum for the plaintiffs, and turns out it was. As we'll see, the plaintiffs made numerous constitutional claims. All of these are facial constitutional claims that the statute is unconstitutional on multiple grounds. The first two are the big ones. First one is that the claim is ICWA exceeds Congress's constitutional authority to legislate in the field of Indian affairs. This is Article 1 of the Constitution, that ICWA just isn't within the scope of the Constitution's permitted authority to Congress to legislate regarding this subject matter: Indian children, Indian families, child custody matters. The second claim, and that's a threatening claim from an Indian law perspective, as we'll talk about in a minute. The second claim is equally threatening. This is the equal protection claim. The claim is that the Indian child definition, meaning the statute doesn't apply unless there is an Indian child, an enrolled member of an Indian tribe under 18 or eligible for enrollment in the tribe with a biological parent who's an enrolled member, that broad definition, that threshold definition triggering application of the acts, plus other provisions of the statute, in particular the placement preferences, that those are racial classifications. And racial classifications are suspect under the Constitution, the equal protection component of the Fifth Amendment's due process clause. And it's really hard to justify suspect classifications like race, particularly in this court, and they're subject to strict scrutiny. And that was the claim, that Indian legislation and the Indian Child Welfare Act was racial, it's subject to strict scrutiny, and it cannot clear that high hurdle. So therefore it's unconstitutional. Two other constitutional claims were that the Indian Child Welfare Act violates the 10th Amendment's anti-commandeering doctrine by telling the states what to do in an area where the Constitution doesn't allow that, and also that the Indian Child Welfare Act violates the non-delegation doctrine because part of the statute allows tribes, by legislation of the tribal governing body, to determine a different placement preference than that set out in the statute. So that supposedly is a delegation to a non-constitutional body, tribal governments, of a constitutional congressional authority. Non-delegation doctrine says you can't do that. So anyway, what happened in the litigation? District court, as they picked a good forum, it worked for the plaintiffs. They got summary judgment on all the counts, the constitutional counts. They won them all. Went to the Fifth Circuit. Fifth Circuit covers Texas, Louisiana. It's based in New Orleans. Three-judge panel reversed on all counts and said all counts, statute is constitutional. And so the plaintiffs then went to an en banc panel, and en banc review was accepted in the Fifth Circuit, and it was interesting. The outcome of the en banc review was a 325-page en banc decision. 17 judges were involved, 7 different opinions. It splintered. On the big issues, the Article 1 scope of authority of Congress to legislate in Indian affairs, the three-judge panel was upheld, and district court was told they were wrong. And so plaintiffs lose, federal defendants, by the now some tribes have intervened on the federal defendants side, won. The second issue, on the equal protection, broad equal protection analysis, which I call the macro equal protection claim, the Indian child definition in particular. The court applied what is known as now the kind of controlling precedent regarding equal protection in Indian legislation. It's called Morton versus Mancari, 1974 Supreme Court decision, which holds that Indian status is not racial, it's political. It stems from primarily membership in a federally recognized tribe, which has a government-to-government political relationship with the United States government. Because it's political, not racial, it's not subject to strict scrutiny. It's subject only to a rational basis test. And typically the rational basis test is provided by the trust responsibility doctrine. And so the en banc panel went for the tribes and the government on both those major counts. But then on the sort of lower level issues of the non-delegation doctrine, the equal protection claim applied to specific placement preferences, what I call the micro level equal protection claims. They went back and forth. They had multiple opinions. Part of it was the statute was struck as unconstitutional. Part of it was upheld and so on. So it was kind of confusing and a little fractured and splintered. So what happens? All sides wanted to go to the Supreme Court on this. Both the plaintiffs, the Brackeens, and the state of Texas submitted cert petitions with multiple questions. All of the issues in their complaint, macro level equal protection, micro level equal protection, Article 1, authority of Congress, non-delegation, commandeering, the whole thing. Supreme Court took all the cert petitions, all the questions, and on the defendant side, the same thing. All the questions, all the cert petitions from the tribes and the federal defendants. Big case in the Supreme Court, 21 amicus briefs. I've never seen that before. In a case. Usually you're told not to submit a whole lot of amicus briefs because they just don't get read. Not this case. Lots of amicus briefs. On the tribal side, 21 amicus briefs. And one of them was on behalf of 497, almost all of the tribes, 72 tribal organizations, 23 states supporting ICWA. On the other side, 8 amicus briefs in support of the individual plaintiffs and Texas. And 2 other states filed amicus briefs supporting Texas, trying to strike down ICWA. 2 hours of oral argument on November 4th. 4 attorneys argued. It was spirited. It's really interesting to listen to the oral argument or read the transcript. Great anxiety in Indian country over the outcome. Most observers predicted a toss-up. They sort of looked at it and said, we can count almost for sure Alito and Thomas will be to strike down ICWA. Almost sure the 3 liberals in Gorsuch will support ICWA. What about the 3 in the middle? Justice Kavanaugh, Justice Roberts, Chief Justice Roberts, and Justice Barrett. That was the question. Most said it's going to be a toss-up, probably a 5-4 vote, depending on how the 3 unknown justices break. So here are the constitutional issues and what's really caused this great anxiety in Indian country, the 2 existential issues, as I described them. The first, the Article 1, authority of Congress. The foundation principle there is the plenary and exclusive power of Congress to legislate in Indian affairs. Big deal. Second issue is the macro level racial discrimination, the equal protection claim. Foundation principles, I said, is the Morton versus Mancari, holding that Indian status is political rather than racial. Thus, Indian legislation isn't subject to strict scrutiny, but just a rational basis, which is always found in the trust responsibility or some other form. What's threatening about those claims and those issues is if the petitioners win on either of those issues, not only would ICWA itself be stricken, declared unconstitutional, but it would cast a very dark cloud over the constitutional status of many, if not most, of the hundreds of Indian statutes, all of Title 26 in the United States Code, and many of the statutes in the Criminal Code, Title 18, that have been enacted by Congress for the past 225 years, beginning in 1790, the first Indian statute, the Trade and Intercourse Act. The criminal statutes would probably be the first challenged. Indian defendants serving time on federal major crimes prosecutions or Indian country crimes prosecution in federal prison would file habeas petitions on the basis that their convictions were rendered by a statute, major crime statute, Indian Country Crimes Act, that are unconstitutional because they're racial and so on and so forth. It was threatening. That could be the consequence of an adverse ruling on either of those first two constitutional issues. The other two issues, anti-commandeering and constitutionality of delegating the non-delegation doctrine, that it would not be that significant. So the outcome, jubilation in Indian country. As I said, nobody predicted a 7-2 outcome. When I heard that from Nina Totenberg driving along Interstate 84 to Hood River, I thought, wow, 7-2. I got to read that. First two, this is Justice Barrett for the court. First two issue, power of Congress. The majority just nails this, thoroughly and completely nails it in favor of the tribes and constitutional authority of Indian legislation. Call it plenary and exclusive. Although Justice Gorsuch in his concurrence said actually plenary is not quite the right word. It's really, maybe you shouldn't call it that. There are some limits. But she said it's a long line of cases establishing that the power is muscular, not free floating. There are some limits, but it's muscular. And then she enumerated the sources of the power, not just the Indian Commerce Clause in Article 1, Section 8, which talks about Congress's authority to regulate commerce between states, tribes, and foreign states, foreign governments. And that's always been thought of as the source of constitutional authority to legislate in the field of Indian affairs. And the court went on to say that's one of the sources, but there are others. And the Commerce Clause is much broader than commerce. And went on to talk about the Treaty Clause in the Constitution, and even pre-constitutional, extra-constitutional sources, the implicit power necessary that's a concomitant of nationality, recognizing that tribes were fully independent, pre-sovereign states, fully sovereign prior to contact. And so the relationship between the federal government and tribes is in effect between foreign governments and the federal constitution. There's a pre-constitutional source of the power to legislate. And even the trust responsibility was extra constitutional as well as a source of power. And then Justice Barrett goes on and lists all these areas where Congress has legislated: criminal law, domestic violence, property tax, and so on, and said, we've only rarely found one of these statutes to exceed Congress's power to regulate commerce. They didn't say where the line is, but it's clearly beyond the Indian Child Welfare Act. That's clearly within the line. And no mention of equal protection as a limit on Congress's power to legislate. Family law, according to the plaintiffs, is outside of Congress's power, and the court said, no, absolutely not. They even scoffed at the arguments of the plaintiffs in some respects and said, you know, they don't tell us which cases they want to overrule. They don't tell us why we should overrule these cases, like Morton versus Mancari or others. And they don't tell us why we should distinguish the long line of cases. So you lose out on that major existential claim. Second issue, equal protection, a less satisfying outcome for tribes. The macro level issue, equal protection across the board, challenging ICWA as applying to Indian children, it's ignored. Micro level challenges ignored as well to the placement preferences. Standing, court held the plaintiffs lacked standing, particularly the redressability issue. You know, we can make a ruling here, but state courts could do something different. It would really be an advisory opinion. You've got to come up through state courts to get this issue before us, the federal court, the U.S. Supreme Court. So equal protection gone, but gone on standing grounds, lack of standing. That's a bit of a concern. So could it come back? And this is also a concern because, from the tribal perspective, because Justice Kavanaugh wrote a concurrence opinion, one-page concurrence, when he said, my view, equal protection issue is serious. Then he go on to say that the court has addressed it, expects it to be addressed in state court foster care and adoption proceedings where the plaintiffs have standing and are denied a particular placement. So I think he's really looking at the micro level equal protection challenges to particular placement preferences. This is my take, my view, and I'm not a constitutional scholar, but this is what I think anyway, that a future macro level, across the board, full on equal protection challenge to a ICWA itself is very unlikely. The 7-2 majority is, I think, really strong support for congressional authorities to enact ICWA. And they even cited Morton versus Mancari, the equal protection authority in the Supreme Court jurisprudence in Indian law. And so I think they impliedly rejected a broad-based equal protection claim that Indian legislation across the board is race-based, subject to strict scrutiny. However, I think that a micro-level equal protection challenge of the sort that Kavanaugh kind of envisions, particularly to the placement preferences, is potentially subject to future ICWA challenges. And in oral argument, there was a hypothetical raised, what about an ICWA case in Whatcom County, Washington, Bellingham, far northwest corner of the country? There's got to be a placement made. Can't keep the family together. The child's extended family isn't a resource. The child's tribe, which may be a local Washington tribe, isn't a resource. So court says now they've come forward and found a tribe in South Florida, the Seminole tribe, and there's a couple there that can be an appropriate placement. Is that placement preferable to a non-Indian couple right there in Bellingham, Washington? That would be the equal protection challenge. It was raised at oral argument, and the answer was that's not going to happen. It's just highly unlikely. So we'll see. Not totally out of the woods on ICWA going forward because of the sort of left hanging court ruling on the standing question and the equal protection issue. Second issue, second big case, Arizona versus Navajo Nation. In reality, this is a consolidated case, Navajo Nation versus the United States. This is we have to talk a little bit about the reserved water rights doctrine and the U.S. trust responsibility doctrine. And both the United States and the Navajo Nation agreed that the tribe has unquantified, unadjudicated, but extant, they exist, reserved water rights in the Colorado River, which borders the Navajo Reservation. And both the United States and the nation agrees the United States has a trust responsibility to the Navajo Nation based on those rights. But what happens when the tribe tries to enforce that in an equitable claim in district court? Here's what we'll see. There are two big cases involved in Indian water rights we have to talk about just briefly, both brought by the United States as trustees for tribe. First is the Winters case. That tells us where Indian reserve water rights came from and what you can do with them. And the second case, Arizona versus California, is how much water, answers the question, how much water is provided by an Indian water right? How do you determine that, and how much water is provided? This is the Milk River in Montana, northeastern Montana, semi-arid area. You can see there's irrigated farmland. This is where the fundamental principles of Indian water law first emerged. The Winters case was set on the Fort Belknap Reservation, set aside in an 1888 statute, really a treaty, as a permanent home for the Assiniboine and Gros Ventre tribes of the northern Great Plains in that part of Montana. It was much smaller than their Aboriginal territory, and the idea was they would cease their buffalo hunting ways and instead become farmers. And to do that, they needed water. The Milk River formed the northern boundary of the reservation, and the problem was upstream diversions of water by state non-Indian farmers with state perfected water rights under the prior appropriation doctrine were taking all the water. And at a time of drought, no water was getting to the Fort Belknap Reservation, so no irrigation was possible. The United States sued to enjoin the upriver water diversions on the grounds that the tribe had water rights based on its established reservation, and those water rights trumped the later state perfected water rights under the prior appropriation doctrine, and they won. The U.S. won, and that's the birth of the Winters Doctrine. Tribes have water impliedly reserved when their reservation is created to fulfill the purposes of the reservation. Most of them, it's agriculture, as in the case of Fort Belknap. And that water right entitles them to enjoin interference with those rights, as was the case in the upriver irrigators diverting water from the reservation. The second case, the Arizona versus California case, this is really a case at issue in this Supreme Court case, Navajo Nation versus Arizona, as it's characterized. The setting is the lower Colorado River. And this is a case, it's really an original jurisdiction Supreme Court case, state versus state. You go to the Supreme Court directly for that. to apportion the waters of the Colorado River, at least between Arizona and California. The United States intervened in this proceeding to make a claim for the water rights of tribes under the winners principle, the winners' rights. And it named the Navajo Nation as one of the tribes it was intervening on behalf of, and along with 24 other tribes. But actually, when the litigation came about, it only involved 5 tribes in terms of quantifying their water rights. And those 5 tribes are on the Colorado River in Arizona mostly, but also in California, downstream from Lake Mead, and they're called the Lower Colorado. And the case stands for the principle the quantification of winners' rights is based on something called practically irrigable acreage. It's a bit of a tongue twister. The PIA standards, it's called. You determine how much water is needed to irrigate the irrigable acreage on a reservation, practically, meaning economically, quantify that, and that's the scope of the tribe's water rights. So here are the Indian reservations on the Colorado River. This is the Colorado here, and this is Lake Mead and the Hoover Dam, and downstream, these are the 5 reservations whose water rights were quantified at the request of the United States. The United States provided the evidence in the Arizona versus California. Here's the Navajo Reservation over here. This is the Colorado River bordering the reservation, and the United States did not make a claim or seek quantification of the Navajo tribe's water rights to the Colorado. Here's the Navajo Reservation here, and you can see that the Colorado River main stem flows along the western side of the reservation and the northern part. 2 major tributaries, the San Juan and the Little Colorado. There is some water quantification with respect to those rivers, but not the main stem of the Colorado. And that's really what's at issue with this case. And because the Colorado is bordering the reservation, it's appurtenant to the reservation, winners' rights attached to the Colorado. The United States admits that. So the Navajo Nation was set aside as a permanent homeland. Permanent home is the language in the 1868 Treaty of Arnett. That's the Navajo language word for the Navajo people, translates to the people. The status of the Navajo's water rights. It's the largest reservation in America by size and by population. The winners' rights to the river that borders the reservation are undetermined. There's been no determination of the purposes of the reservation. The winner's scope attaches to the purpose, the protected water fulfill the purposes of the reservation. Almost certainly agriculture is one for the Navajo Reservation. And no determination of the quantity by PI measurement or otherwise. The Navajo Nation has tried over and over again for years to get the United States to act on its behalf as trustee to determine the scope and quantity of the tribe's Colorado River water rights. Failed. Tribe itself intervened in Arizona versus California, or attempted to, and the United States opposed the tribe's intervention in Arizona versus Colorado, which is California, which is the case quantifying water rights for at least 5 tribes on the Lower Colorado. The United States opposed, and intervention was denied. So that's the status. And how does that relate to the trust responsibility? Trust responsibility doctrine is another Indian law doctrine that goes way back and to 1831. Really founded, as described by Chief Justice John Marshall, as the nature of the relationship between tribes and the federal government. And legal actions to enforce the trust responsibility basically fall into 2 categories. Claims for breach of trust for money damages, that goes to one court, one place, one set of statutes are involved, and one set of case law that defines what a cause of action is for a breach of trust. A second category are claims for equitable relief. And we'll look at the cases that address both of those routes. The Navajo claim is a claim for equitable relief in the district court. Cherokee Nation versus Georgia is a great case from 1831. Chief Justice John Marshall trying to describe whether the Cherokees were entitled to bring a claim in court in original jurisdiction in the Supreme Court, because they're suing the state of Georgia, which is trying to obliterate the reservation. This led eventually to the Long Walk and the Cherokees' banishment to Indian territory that became Oklahoma. So Cherokees can't get any help from the president. That's Andrew Jackson, and he's totally for the state of Georgia. Legislature, Congress is too. So they go to the Supreme Court and say, we're a state, we're a foreign state able to invoke Supreme Court jurisdiction under the Constitution. And Justice Marshall said, no, you're a state, but you're not a foreign state. Then he goes on to describe what tribes are. This means they don't have the ability to go to the Supreme Court. They lose on jurisdictional grounds. He calls them domestic dependent nations. But then this language is considered the origin of the trust responsibility, where Chief Justice Marshall said tribes are in a state of pupillage. Their relationship to the United States resembles that of a ward to his guardian. Justice Thomas, by the way, said that's dicta. That's just dicta. If that's the source of the trust responsibility doctrine, it really doesn't count for precedent. So what about the trust responsibility doctrine? Is it actionable? Can you sue on it? Can a tribe sue the United States for breach of trust? The answer is yes, but there are two branches that have emerged, whether it's a claim for money damages or whether it's a claim for equitable relief. And both of them you have to have, it's not easy to sue the federal government. So you have to have, number one, a federal waiver of sovereign immunity to allow the claim to be brought. And second, you have to have a recognized cause of action. So these two branches, claims for money damages, claims for equitable relief, have pursued different waiver statutes, Tucker Act for claims for money damages, and APA and 28 USC section 1362 for equitable claims in district court. And they go to district court for the equitable claims. You go to the Court of Federal Claims. The Conqueror's Court, as the tribal attorneys call it, the Court of Federal Claims in Washington, D.C., the CFC, and you have different causes of action. The money damages cases started with the Mitchell cases. These little white dots are called allotments on the Quinault Reservation on the Washington coast. And each of them was formed by the federal statute, the 1887 Dawes Act, to give individual tribal members a piece, 160-acre parcel of a Indian reservation. Those are called trust allotments. The Quinault Reservation is mostly forested, so the allottees brought a claim for breach of trust in the Court of Federal Claims. And they first said that the Allotment Act, the Dawes Act of 1887, was their cause of action. And the Supreme Court said, no, that's a bare trust. It's not sufficiently detailed to create a cause of action. So they came back a few years later and pointed to specific statutes imposing on the Bureau of Indian Affairs management responsibilities for managing allottees' timber. And the Supreme Court said, yes, that's it. That's a cause of action, establishes a fiduciary relationship. It mandates compensation, at least impliedly, if not expressly. Therefore, you can go forward with your claim in the Court of Federal Claims for money damages. That's a cause of action. They already had the waiver of federal sovereign immunity in the Tucker Act and the Indian Tucker Act, so they met all the requirements. Branch two, equitable claims. The most famous recent example is the Cobell case by 500,000 tribal members, individual Indian money account holders, requesting equitable relief in the federal district court in Washington, D.C. They wanted an accounting. How much money is in my IIM account? Where did it come from? Is it accurate? What's happening with my IIM account? These are all held in trust accounts held by the government, called these IIM accounts. So it's in the Court of Federal Claims, and relief was based on common law trust principles, also on the 1994 Trust Reform Act, but primarily on common law. And the request for equitable relief in the form of a historical counting was considered a traditional one from common law trust duties imposed on a fiduciary to the beneficiaries, referencing general trust law. So the Navajo Nation's request for relief in this case is an equitable claim. And they asked, according to the majority, that the court order the United States to take affirmative steps. First one would be to assess, essentially an accounting of the tribe's water needs, which the United States has never done before, then develop a plan to secure the needed water, then potentially, and this may be where they ran into some trouble, potentially build wells, pipelines, and other water infrastructure. And so This maybe looked to the majority like it went beyond a simple equitable claim for relief, and actually talked about requiring the government to spend money to build infrastructure and so on, and maybe look more like a money damages claim. So it may have sort of merged over into the first branch of claims for money damages, which require, at least based on case law, a more detailed and specific support for the cause of action. The Navajos pointed to their treaty as the cause of action, and the Supreme Court said, no, there's no mention of water in the 1868 treaty. There has to be something more detailed. There has to be some statutes. There has to be some regulations, more like timber management obligations the government assumed in the Mitchell case, in Mitchell 2. And so as a result, they lost. And it appears that going forward in equitable claims for breach of trust, tribes are going to have to point to something more than a general treaty obligation, which the court called a bare trust. So what can the court do? This, by the way, this is what this court said, is that they cited Mitchell too for the idea that you have to have a more detailed set of trust creating fiduciary obligations created by statute, even treaty, but 1868 treaties typically don't carry those kinds of specific obligations, at least not with a broad obligation to protect winners' water rights, regulations and statutes and so on. And they specifically said the United States is a sovereign, not a private trustee. So they're disavowing the application of common law trust principles. And they almost decided this on separation of powers duties and separation of powers principles, that the trust obligations have got to be established by Congress and not the judiciary. So the Navajo tribe loses out. And then the question becomes, and Justice Gorsuch discusses this as his concurrence, what can the tribe do? They've got a treaty right, a winner's right to water from the Colorado River, from the main stem of the Colorado River. The United States is trustee for those rights. What can they do? How to get those rights protected? One thing the court said is, Justice Gorsuch, the Supreme Court in this case did not rule on whether the United Nations could bring a claim against the United States for interference, whether it's water rights, or try to intervene again in Arizona versus California. And Justice Gorsuch said the United States cannot possibly object to the intervention this time. They would be stopped from doing that. So we'll see what happens going forward. And I think we can see more action in this case going forward. Let me quickly cover the last case, the Lac de Flambeau case. This case involved, it doesn't really change the legal principles apply, but the 8-1 ruling is a bit of a surprise, and it may be because of the underlying facts. The tribe operates, the Lac de Flambeau band of Chippewa Indians from Lake Superior Chippewas from Wisconsin, operate a payday loan business. Payday loan businesses are not really popular, and they, as you know, probably know, they make short-term, high-interest loans. And in this case, the tribe's business, which is cloaked with the tribe's tribal sovereign immunity, which Justice Thomas said, that's something we just made up. It doesn't really exist outside of our jurisprudence, and it's not from the Constitution. We should get rid of it. But anyway, it exists. And the tribal business enterprise aggressively pursued collection actions against Coughlin after he had filed Chapter 13 bankruptcy, which imposes the automatic stay. Who does the automatic stay apply to? Under the bankruptcy code, it applies to governments, governmental units. Who are those? Statute doesn't mention tribes. If it said the governmental units includes tribe, that would be the end of it. That would be an express congressional waiver of tribal sovereign immunity in applying the bankruptcy code, including the automatic stay provisions directly to tribes. Tribes are not mentioned. So the statute doesn't appear to, on its face, meet this demanding standard of a clear statement from Congress, clear statement that Congress intended to abrogate tribal sovereign immunity. But the court, by 8-1, decides Congress really did intend to apply the bankruptcy code, including the automatic stay provisions, to all governmental units, because there's a catch-all that defines governmental units to include domestic and foreign governments, and tribes or governments. So they've got to be in there and intended to be covered. Gorsuch says actually tribes are a hybrid. They're neither foreign, they're neither nor domestic. So it's actually ambiguous, and therefore it doesn't meet the clear statement rule. But the majority, by 8-1, Justice Jackson, one of the new members of the court for the so-called liberal bloc, wrote the opinion. And I thought it was particularly telling that some of the difficult facts appeared in the opinion, including Coughlin claiming significant emotional distress caused by the collection actions in violation of the stay that led him to attempt to take his own life. And the court mentioned it in the opinion. So it probably had a strong influence. As they say on the law, this was a close call. The Ninth Circuit and the First Circuit said the Bankruptcy Act applied. The Sixth Circuit said it didn't. Even in the First Circuit, where the case came from, the lower court, the three-judge panel in the First Circuit was split, so it wasn't a unanimous opinion. And the bankruptcy court, which had heard it first, said that bankruptcy code did not apply. So on the law, close case. In the Supreme Court, not. So just the message from that is bad facts, troubling facts, difficult facts can result in unfavorable outcomes. So that's it. That's my quick tour of, oh, by the way, I did want to talk quickly about Justice Gorsuch and Justice Thomas again. As I say, they're aligned in a lot of cases, but on Indian law, definitely not. And Justice Gorsuch goes on in beautiful long prose about the history and development of all of these pillars of federal Indian law: congressional power to legislate, trust responsibility, water rights doctrine, canons of construction, which are an aspect of the trust responsibility, inherent nature of tribal sovereignty, and so on. Justice Thomas is just at the other end of the universe and the solar system on this stuff. All of these doctrines are, in his view, judicially created, no foundation in the Constitution at all, and the court should revisit them. And it's pretty clear that if it were totally up to Justice Thomas, there would probably be no Indian law in the Supreme Court. So that's a takeaway, and I think that will be a theme in future cases, in the Supreme Court going forward. So that's it.
Great. Thank you so much, Professor Arnett. We do have a question that seems to be sort of piggybacking on your discussion of the trust responsibility doctrine. And it is, one of the problems with the plenary power doctrine was that it came up roughly when the USA stopped making treaties with the tribes. And as a result, the tribes stopped having nation-to-nation negotiation status with the US. Would Justice Thomas's attempt to undo the last 150 years of Indian law require him to accept that tribes are not a part of the United States and instead are still domestic dependent nations?
Well, it's hard to say where Justice Thomas would go. He has pointed out about the plenary power doctrine, and accurately, that it's a double-edged sword, that it's been used historically in the past, mostly in a manner that's adverse to tribal interests. The famous, probably the most infamous case in Indian law is Lone Wolf versus Hitchcock, in which Supreme Court said a congressional statute that clearly abrogates a treaty, violates a treaty, is unconstitutional, beyond their authority. And the Supreme Court said, no, that's not right. Congress has plenary power and it's unreviewable. You have a complaint about Congress's action, go to Congress, complain to the political body. But, and that's the plenary power. That's the plenary power doctrine. In recent years, the plenary power doctrine has been used in an affirmative way. Things like the Indian Child Welfare Act, things like the Duro fix, reversing Supreme Court decisions that were adverse to tribes about the scope of inherent sovereignty, and the amendments to the Violence Against Women Act, extending tribal criminal jurisdiction over non-Indians in certain circumstances. That's an exercise of the plenary power to the positive. And Thomas says, well, you can't be both. You can't say it's used for good and used for bad from a tribal perspective, and call it some kind of a workable doctrine. So I'm not sure where Thomas would say tribes exist in the structure. They're in the Constitution. They're in the Indian Commerce Clause, one of the three categories of government, states and foreign nations and tribes. So they can't be read totally out of existence. They exist. But from Thomas's viewpoint, the Indian Commerce Clause means trade, means commerce only. That's the limit of Congress's authority to enact legislation regarding Indian tribes. Otherwise, the rest of it is unconstitutional.
Thank you so much. We do have a few extra minutes. If anybody would like to type any questions, please feel free to do so. I have a question for you. This is a more functional. Is it? Do we have your permission to share these slides if
Absolutely.
requested?
Sure.
Okay,
No,
fantastic.
no pride of authorship at all. So
Okay, great. So
sure.
attendees, if when you submit your Oregon State Bar number, if you'd like to have us send back Professor Arnett's slides to the presentation, we'll be happy to do so. A lot of great information in there.
Thanks.
All right, looks like we do have another question. Many tribes are interested in protecting in-stream flows. How does the Navajo decision impact those negotiations with the federal government?
Well, I still think there is a claim for relief in the Ninth Circuit upheld in the Adair case with respect to in-stream flows for the purposes of the Klamath Reservation, the former Klamath Reservation, for hunting and fishing. And that's an express purpose of the treaty that set up the 1864 treaty that set up the Klamath Reservation. In addition to the purpose of agriculture, so a claim for withdrawing water for irrigated agriculture. So in-stream flow rights, I think, can be premised on in a treaty provision, claim for equitable relief, where you have a specific treaty provision like the Klamath Treaty did in the Adair case. And that becomes a purpose of the reservation, which under Winters is a protected right. And that is different. It's an in-stream flow right. It's a water quality right rather than a right to withdraw water for the other purpose, the agricultural purpose. So I think it's, if you have the right treaty and other support for that, there is a cause of action.
Thank you. Just a couple minutes left. If anybody has any other thoughts or questions for Professor Arnett. Okay, it looks quiet. Well, I want to just thank you so much, Professor Arnett, for joining us today and leading us through this really fascinating discussion. And thank you to all the attendees for joining us today as well. Everyone stay tuned for more information about future Oregon Law Perspective webinars. Thank you so much. Have a great day. Take care, everyone.
Okay, thank you.
Bye-bye.
Thank you very much.